what is this topic about? This topic is the third in our consideration of the 4 elements of agreement or of contract. So in order to have a legally enforceable contract, we need to have agreement comprising offer and acceptance. But if we can't find that, then consensus ad idem, a meeting of the minds of some sort. We need to have consideration. So in other words, we need to be able to demonstrate that there is a price for each promise that is made. Consideration needs to move from the promisee to the promisor. Consideration needs to be legally sufficient. So that means it has to be made in relation to the bargain. So the consideration often needs to relate to the bargain that has been made, and it needs to happen as a consequence of the agreement that people have entered into. So the promises need to relate to each other, which means past consideration, something that somebody has done before the bargain has been made, can't be legally sufficient consideration. Consideration needs to be sufficient, but it doesn't need to be adequate. So it doesn't matter if one party's price is considerably lower than the other party's price. What matters is that there is an exchange. There are circumstances where we don't need consideration. That would be firstly, and the easy one to get rid of, is if the bargain is documented under a deed. Some historical reasons, largely to do with the importance of that instrument, we don't need consideration. The requirement for consideration also doesn't exist if one of the exceptions applies. So we spent quite a bit of time last time talking in particular about the practical benefit exception. And the thing to remember there is that if the exception applies, if there's an argument that the exception applies, that means we don't need consideration. It's not that the practical benefit becomes the consideration. Slightly different. What have I forgotten? I'm trying to do a really high-level overview of where we're up to now. Let's not talk about options. No options today. But we need consideration for an option. An existing legal duty. Performing an existing legal duty is not sufficient consideration. It's like past consideration. It doesn't relate to the bargain. The next 2 elements are intention, which is the one we're going to talk about today, and certainty, which we're going to talk about in week 7. But we started talking about today when Sue was here. And her slide, which you'll get copies of, summarises the 3 main points for, she's, spoiler alert, she's killed me here, but essentially for an agreement to be sufficiently certain, then we need to know what the terms are. So it needs to be certain as in clear. It needs to be not illusory. It's probably a bit mean to her, but I didn't agree with her analysis there about what not illusory means. The easier way to think about not illusory is that it's not so discretionary as it means that somebody isn't really making a promise. Because consideration, remember these all link together in their own way, consideration needs to relate to the bargain. So if, for example, in Meehan and Jones, if the term had actually said, this contract is subject to finance being acceptable to the vendor, so it just said subject to finance, and if it was finance acceptable to the vendor, then that would be an illusory promise. I'm going to sell that to you, provided you get finance on terms that I'm happy with. Because that's really giving you the discretion whether to go ahead with the deal or not, right? You're not borrowing the money. It's none of your business as the vendor what the terms are. You can just say you don't agree. I don't like those terms. I don't like that bank. Okay? So illusory promises are one where there isn't really any understanding or any... The promise is so broad or the condition is so broad that somebody has discretion. So the case we particularly look at for that is called Shahid and the College of Dermatologists, I think, which again is another case that really annoys me because I think it's a misogynistic case where they also probably didn't like the colour of her skin. But long story short, Dr. Shahid, she wants to join the College of Dermatologists. That basically means that she can practice as a dermatologist. They have an exam, she sits it and passes, they say no. So she sits it again, she still passes, they say no. They say, oh, well, we can review the decision, but you'll have to pay some money. So they've got some rules, you have to pay some money to get the decision reviewed. So she goes and she does that, and they still say no. And so she says, well, look, actually this isn't fair. I paid money, there was a contract, I did the things you asked me to do. Your side of the contract is you should make me a member of your club. They say, no, we had no intention to enter into a legal relationship with you. But we will talk about this case today. We had no intention. We're a club, we're a membership base, and we've got the right to say no to people if we want to. But they also said, we had these processes, but we can still say no. And the court said, well, no, if you're going to set out a process, you're going to deal with all those things, it's absolutely okay for the other party to believe that you had an intention to deal with those things in the way that you said. And if they're paying money and there's a process for review, then they should follow that process. Yes, it's a contract. Okay. We'll get to that one. I'm going to be doing high-level summaries today. That's the way we're going to roll. So the last of these is intention. We could do them in any order at the end of the day because we need all of them to have a contract. Any one of them is missing, we don't have a contract. So this is my general, how do we work out whether or not we have intention or not? So the general rule is we need to have a voluntary assumption of a legally enforceable duty in order for an intention to exist. So no gun at your head, nothing like that. We need the parties to voluntarily decide that they want to take on a legal duty. Now, one of the issues I suspect that they had in this case I hadn't heard of before that Sue was mentioning earlier, Toe and somebody, the engagement ring case, is actually just on objective standards. The question would be, is a decision to get married intended to be a legally enforceable arrangement, or is it a social or domestic arrangement? And we'll talk about the presumptions as we go forward here. So, basically two questions. We'll go down the first round first. Firstly, if there is no express statement, so if the parties don't actually say, I intend to be legally bound to this contract, or our intention is that this is a legally binding relationship, then the question becomes, how do we work it out? So there are basically two types of potential relationships here. Commercial relationships or family and social relationships. That's where we deal with the things called presumptions. And for those of you who are online, I think I gave some feedback on a discussion board task recently, and I'll share it here. There was people using the words assumptions and presumptions. Don't have a look in the dictionary, they pretty much mean the same thing in general English usage. So I assume this, or I presume that, pretty much mean the same thing, although the weight is that presumption is I've probably got more data behind a presumption than I have against an assumption. It's slightly vaguer. When we're using technical legal language, again, they're very, very similar, but they're used slightly different ways. When we're doing a legal problem or we're starting some sort of analysis of a case, we quite often have to make assumptions. So we're going, unless otherwise told, you should assume that all the parties are in Victoria, or that all of the parties are adults. You might make an assumption like that when you're looking at, if you're not told. A presumption is something that the court does, and it's usually a starting point. So, when you go to court and you've got a dispute, you need to be able to establish what your cause of action is before the court. Now, in most cases, I hate to tell you this stage, in week 6 of your contract course, if you've got a dispute about a contract, the court will start from the presumption that there is a binding legal agreement between the parties and go straight to the matter in dispute. But it's a rebuttable presumption. So if you're a party to a dispute and somebody is claiming that you've breached a contract, it's perfectly reasonable for you to do a double take and say, okay, maybe we didn't have a contract in the first place, because if there's no contract, I can't breach it. So in fact, you would be going to the court and you would be arguing no contract, therefore no cause of action. And you'll see in a number of the more modern cases which we look at in this subject, you'll see that there are alternative arguments. So, you know, version 1, no cause of action because there was no contract, therefore we can't breach it. But even if we fail on point 1, then for the reasons under point 2, we shouldn't be found to be in breach anyway. Okay, so a presumption is just a starting point. It's kind of like a shorthand. So the starting points that we talk about in intention are twofold: commercial transaction or non-commercial transaction. In a commercial transaction, the presumption is that the parties intended for it to be a legally binding relationship. So that means that if you want to demonstrate that there's no contract because you never intended for it to be legally binding, then you need to bring evidence to show that. In family and social relationships, so I wanted to get married, I promised you a car when you turned 21 if you got a particular ATAR. I said I would show up at 6:30 at an online shoot, and instead I was eating dinner and I didn't get there until 7. Am I in breach of contract? Is it, if it's a social, well, that's probably not a social relationship, but nonetheless, was it a social relationship? The presumption is amongst family members, amongst friends, they don't intend to sue each other if things go wrong. That we enter into agreements all the time with people, and we keep our promises because that's the right thing to do and we care about people, not because we've got the long arm of the law behind us. But if in fact we did intend for it to be a legally binding relationship, then again, the presumption is rebuttable. And there are lots of cases, I'm going to whiz through them, setting up how we rebut the presumption. But since the case of Ermogenous, which is the key case in this area now, essentially the value of the presumptions is down to the question of who needs to bring evidence. And it pretty much works like this. If it's a commercial transaction and a party wants to demonstrate that it wasn't intended to be legally binding, then that party needs to bring the evidence to show that, to rebut the presumption. And if it's a family relationship, or a social or domestic relationship, or a relationship between a bishop and his church, then the presumption is it's a social relationship, but all that means is the party who wants to show that it's actually intended to be binding is the party who needs to bring that evidence. Okay? This is the simplest one. So where do the difficulties, having said it's the simplest, where do the difficulties arise? They arise particularly in relation to honour clauses and letters of comfort. So I'll take you through a couple of cases there because they won't necessarily be obvious to you. Questions, concerns, thoughts? Because I feel like I've just done a high level of the whole topic just then. So, intention, straight from your textbook. Whether the parties appeared to intend to create a binding agreement is relevant to the question of whether a bargain has been struck and each party has paid for the promises made by the others. So the language starts off here, going to a test that we're really familiar with. Does it look like they intended to enter into a legal relationship? Does it sound like they intended to enter into a legal relationship? Let's use an objective test to identify. Doesn't matter what they actually thought, doesn't matter what information they were caging away themselves, we still use an objective test. You can see, I hope, how this all folds itself in as well with offer and acceptance. So agreement is made at the point in time where the offer is accepted. So the offer itself and the act of accepting are part and parcel of the demonstration of that objective test that the parties intended to enter into a legally binding relationship. So when the parties, for example, use a deed, a very formal instrument, to write down what their agreement is, there is a presumption that they probably intended it to be binding. When they use words that say, we intend to be bound by this, in consideration of the promises made in this deed, the parties intend to be legally bound. That kind of language is the sort of thing that we see regularly. But similarly, particularly in commercial transactions, parties might actually state, we don't intend to be bound yet, or only these clauses are going to be binding on us. Particularly in large, complex transactions, when the parties are still negotiating things like the price, or when the transfer of an asset will happen, or say in a sale and purchase of a business, when employees might move from one place to another, or what the conditions might be. Sometimes you need to actually have some things that are binding, like I might not want my employees to know that I'm thinking about selling my business, so if I'm negotiating with Alice to sell my business to her, I might want a confidentiality undertaking. I might not want my competitors to know, or my employees. I don't want to skittle anything until we've agreed the price. So I might want to have a binding confidentiality agreement with her, and she might be quite keen for it to be an exclusive arrangement, so she knows that I'm the only person that she's treating with, that she's the only person I'm treating with. We might want to have that piece binding, but anything at the moment to do with the price, or even what the business is, or even whether I have a business to sell you, Alice, all of that stuff, that's still open for negotiation. Do you see the difference? So we might have a preliminary agreement, is usually what we call them, where we say, okay, indicative price, $10 billion, we'll probably settle it by Christmas Eve. None of those things are intended to be binding on anybody at this stage, but the confidentiality provisions are quite common. Right, I'm looking for whether I'm boring you, or I feel like I'm doing lots of words at you at the moment. So, as I said, an objective test. Did the parties manifest an intention to create a legal relationship? Important words. Intention is determined by whether a reasonable person regards the agreement as intended to be binding, not by what the parties actually intended. So this is Merritt and Merritt. So in that case, the parties basically owned a house together, but Mr. Merritt went to live with another lady. They made an agreement that he would pay her 40 quid a month and ultimately transfer the house to her. She was going to pay him. Oh, she had to pay the mortgage. That's right, she had to pay the mortgage. He would pay her 40 quid a month and eventually transfer the house. And so essentially, he, being the worm that he was, going off with his other lady friend, reneged on the deal. So what did the court say? Anybody remember? I can see some nods there as you remember the facts. What did the court say?
They said there was a contract.
They said there was a contract because an objective person looking at the circumstances, how acrimonious the relationship was at that point, would assume that they had settled this matter in a bona fide way.
And they put in an informal written.
That's right, they had an informal arrangement, and there was all sorts of trouble getting that thing written down. So they looked at this whole thing, right? Bloody worm letting down his, getting out of the deal, or trying to get out of the deal by saying that they shouldn't do it because they were married. What else have we got? Air Great Lakes is another good one. That case is actually not in your textbook but available to you. Another one where they take into account the surrounding circumstances, looking at the actions and statements of the parties as well as the terms of the document. So again, we're just applying an objective test. I do like a quote from our friend Lord Denning. The court does not try to discover the intention by looking into the minds of the parties. It looks at the situation in which they were placed and asks itself, would a reasonable person regard the agreement as intending to be binding? Or would reasonable people? So, what factors does a court decide that a reasonable person would take into account? So let's have a look at Shahid, which I mentioned earlier. Really shouldn't get ahead of myself like that, should I? I like Shahid. Presumptions, let me have a look here. We've talked about presumptions already. Let me see, where do I want to go? So, Ermogenous was the court case about the bishop. So I've only flipped through a couple. So, Ermogenous was the bishop of the Greek Orthodox community in South Australia. He worked for that community for 23 years. He went to baptisms, he went to weddings, he went to funerals, he comforted grieving widows, he ate pound cake and baklava, I have no doubt, on many, many occasions. He didn't get holidays, he didn't get long service leave, and after 23 years, he resigned. And they said, off you go. And he said, hang on a minute. I have worked slavishly for this community for all that time. I need some long service leave. I need some holiday pay. I need to be remunerated for my services. And they said, but fish, you're doing this for the love of God and for the community. It was your privilege to serve us. This was a social relationship. This is a religious relationship. This is not a dirty, grubby commercial relationship. And so ultimately, it ended up in the High Court. And they said, well, the presumption here is with a social or domestic relationship that it's not intended to be legally binding. And the court said, well, actually, these are not hard rules. And we need to be really careful here that we don't use the word they use was ossifying. That the presumptions don't ossify into a rule of law. In each case, we need to look at the facts and ask ourselves, as per Shahid, which Shahid I think is after Ermogenous. Somebody can do a quick Jade bubble search for, I call them bubbles, not balls, by the way. They can do a search and let me know. Each case it depends on its facts. At best, they said the presumptions identify who bears the onus of proof. And I like this from the judgment. Not only is there an obvious difficulty in formulating the rules intended to prescribe the kinds of cases in which an intention to create contractual relations should or should not be found to exist, it would be wrong to do so. And when we think about that, to me that makes a lot of sense, because it's in social, domestic, and dare I say it, religious or club environments that people are most likely to be taken advantage of. And so if there is an intention for there to be a legal relationship, then it should be possible for a legal relationship to be found and not to be in the position where one party who has the upper hand can rely on the availability of a presumption to slide out of a promise that they otherwise made. That would be my view anyway. So how do we find whether there's an intention to create contractual relationships or not? Again, coming back to Ermogenous, we start with what the subject matter is. So what is this kind of contract? So in Ermogenous, to the extent that they found a contract, which they did, it was a contract of employment. The terms of their agreement were what this guy was going to do for the community. The status of the parties. So in this particular case, the church was the equivalent of the board of directors, the equivalent of the company that employed him, and he was subject to their directions and to their rules. The kinds of relationships that they had with each other. In this case, the High Court took into account that he was subordinate to the ordinance of the church overall. And what we always love in objective cases, the test includes other objective surrounding circumstances. So, subsequent to Ermogenous, essentially, this is about looking at the presumptions. So the importance of presumptions relates basically to the onus of proof. If we have a commercial party who's denying that there was intention to create legal relationship in a commercial transaction, then that party bears the onus of establishing that there was no intention. On the other hand, if we've got a family relationship, so let's say a brother that's asserting that a contract that he has with his sister is a social or a domestic relationship and not a legal one, then he bears the onus of proving that it was not. Sorry, the other way around. So the onus of proof. So what do we do to determine? Usually it's going to be clear from the nature of and circumstances surrounding the agreement made, but if it's not clear, then the courts are going to use an objective test, and the onus of proving legal intention rests with the party alleging that the contract exists. So I said to you before that there are tricky situations in commercial contracts, particularly honour clauses and letters of comfort. So, commercial transactions are presumed to be intended to be legally binding, and it's very rarely an issue. We've got a couple of recent cases though, which not so much on the commercial side, but on the social and domestic ones. So it's kind of nice to have a case from this millennia every now and then, and I think we've even got them from this decade this time, which is, I like. But let's, before we get there, let's talk about the letters of comfort. So does anybody know what a letter of comfort is?
Yeah.
Jack, have a go. What's a letter of comfort?
It's like a letter usually from a parent company to a bank when the subsidiary of that parent company is asked for a loan from the bank and they're not able to pay. The bank wants to know the parent company.
Perfect.
There's no liability.
Well, this is what these cases are about. This is where it gets tricky. So basically, situation, in fact, why don't I go to the facts of the first case? What have we got here? I'm sorry, I'm just going to go through to the letter of comfort case. Here we go. So the first case in this area is ANI and Spedley Holdings. These names mean anything to you? They were large listed companies in the 80s. Christopher Skase, anybody heard that name? So he was the chair, or he was a major shareholder in Spedley. He was the one who ended up, he went to Morocco, I think, claimed that he was very, very ill, always had the gas mask on his face. One of those comedy shows used to lampoon him terribly. So he's one of sort of Australia's first corporate collapse. It was Mallorca, that's right. You do remember him, don't you, Michael? Christopher Skase? Yeah. He did die eventually. Took a long time to go though, given how ill he was during all of those proceedings. But anyway, so Spedley, ANI, again, big listed company back in the day. ANI owned 45% of Spedley. And Spedley in return owned 100% of a company called Spedley Securities. And Spedley Securities was essentially traded on the stock exchange. Banque Brussels loaned, actually the numbers seem so small now. I know 5 million, what's 5 million between friends really, but when you look at the size of what happened subsequently with Pyramid and the hospital, the health insurer, just gone from me. HIH. I was thinking HBH, and I'm thinking that's not right. HIH says these are quite small numbers. So Bank Brussels basically was considering lending $5 million to Spedley, so Spedley Securities. And they were worried that Spedley might not pay it back. Okay, so they were going to advance that for securities trading. So they said to ANI, okay, can you give us some security here? And ANI said, no, I'm not going to give you any security for this loan, but we'll give you a letter of comfort. And so let me see if I've got any of the terms of the letter of comfort here. Yes, I do. So basically it had two relevant terms. The letter said, it's our practice to ensure that our affiliate, Spedley Securities, will at all times be in a position to meet its financial obligations as they fall due. And secondly, if we cease owning 45% of Spedley Holdings, so the parent company, then we're going to tell you 90 days before we change the ownership. So why do you think the bank would have looked for that 90 days clause? I'm assuming that ANI didn't offer it, that the bank said this is what we want to see. So why would they have wanted that?
Do you know how likely they would not pay the loan back?
So they wanted to know how likely it would be?
No, how likely they would not pay back? Because if they sold it, it's more likely that they'll go bust.
Yeah, look, they're basically saying, well, if the protection we've got is that this big listed company is going to stand behind the loan and it's going to be bad for them, they're going to have reputational damage if they don't support it, and they've got a practice of ensuring that their affiliated companies are cashed up, then provided that ANI continues to have that investment, we're safe enough. But our risk changes if ANI ceases to be an owner of Spedley Holdings. So we want 90 days notice. If you're going to sell those shares, because Spedley Holdings was listed, if you're going to sell those shares, then we want to know so that we can call in a loan in that 90-day period and get paid up. Or we can find alternative security, whatever it is. Okay, so it's important to understand the commercial relationship so that we get our heads around what the promises were. ANI ultimately sold those shares without giving the notice. There was quite a big disruption in the stock exchange, I think late 88, somewhere around there, and there were a lot of collapses that came out of that. So Bank Brussels ended up suing ANI in contract, saying, you made a promise to us that you would ensure that your affiliate Spedley would be at all times in a position to meet its financial obligations. Spedley hasn't paid that $5 million back, and so you've made a contractual promise to us to sort that out. And the issue before the court became, what was the legal effect of the letter of comfort? Was there an intention that ANI would be bound by that? And if there was, then there was a promise made, and let's assume for now they can demonstrate the other factors. So what happened? What do we think? Even if you haven't read it, have a go. Based on the language you can see.
So it was.
Sorry?
So there was a contract.
We've got a vote for was over there.
I think from memory, the security itself wasn't legally binding with the 90 days clause. Two questions about there. So, were the questions sufficiently promissory? Held. Starting point is the prima facie presumption that in commercial transactions there's an intention to create legal relations, and the onus of proving the absence of that intention rests with the party who asserts no legal effect is intended. So in this case, if the statements were promissory in character, then the courts can enforce them when they're uttered in the course of business and when there's no clear indication they're not intended to be enforced. And the letter that ANI gave included an enforceable contractual promise to provide that notice. So the bank was entitled to damages because the notice wasn't promised. The promised notice wasn't given.
So you're right that there was found to be no security. It was a promise to support, but the bank suffered damage. So it was able to then quantify that damage. So then, though, that leads us on to a contrasting case, which was decided the same year. This is a UK case, Kleinwort, Benson and Malaysia. So let me just walk you through what the facts are. Oh, sorry, the terms on the letter here said very similar. I'll show you the map in a second. After lengthy negotiations, there was a letter that says, it is our policy to ensure that the subsidiary is at all times in a position to meet its liabilities to you. So not terribly different wording, but different nonetheless. In this case, the bank Kleinwort Benson was lending 10 million quids to MMC Metals. MMC Metals was 100% owned by Malaysian Mining Corporation. So we don't even have the 45% issue, there's 100% ownership. There were 2 letters of comfort given, and there was also an agreement between MMC and Kleinwort. Similar thing, the bottom came out of the tin market, MMC wasn't able to meet its debts. There's facts here. In the first instance, in this case, it was held that commercial people intend their agreements to be binding, and the letter that contained a contractual undertaking was effectively an underwriting of the indebtedness. But on appeal, it was held that the letter didn't contain a contractual undertaking, but was merely a representation of facts that only carried with it a moral obligation on the part of MMC. So the letter itself, the terms of the letter, and the conduct of the parties were what the court take into account. Now, some people might see these as being really similar facts, 2 very, very different results. I don't see them that way at all. I see them as entirely consistent because the subtleties in the difference of the facts are what makes a difference. Firstly, in the first case, in A&I, the promise was, it's our practice to insure at all times, as opposed to, it's our policy. Okay. Tiny difference, but a difference nonetheless. Secondly, the correspondence and all of the activities beforehand demonstrated that when they were asked for a security, they said no. They were very clear that they had no intention of giving a security, that they had an overall policy in relation to the financing of the group. But at the end of the day, the reason that they have these structures was so that, to paraphrase Lord Denning from a case I don't necessarily remember the name of, let me find it here, is so that gentlemen can take risks with other gentlemen's money. If they were prepared to give security, then why create a subsidiary? They could have done that trading on the tin market themselves. And they could have taken the risk, and because of the size and the assets of that company, Kleinwort Benson would have no difficulty lending the money, and if they didn't pay it back, they would have a direct contract, they would be fine. But actually, they created this subsidiary precisely for this reason, to take risks on the tin market. And at the end of the day, whatever Kleinwort Benson, whatever interest they wanted to charge, they could factor that in on the risk. So the facts actually supported, our intention was that MMC Metals should be bound under that loan agreement. But at the end of the day, if it's not going to survive, we're going to cut it off. We'll wind it up. So every time we need to look at the facts. Questions, concerns, frustrations, as I'm moving super fast. Family and social relations. Lots of cases here. Since Ermogenous, I don't think you really need to worry about these beyond understanding what the the presumptions are and where they come from. So we've got lots of cases in this space, usually about people who make promises to each other and then the relationships break down. Balfour and Balfour we always include because it has that lovely quote from Lord Justice Aitken: natural love and affection counts for so little in these cold courts. Making this moral judgment really that at the end of the day that promises a husband makes to a wife, they aren't intended to be legally binding. So we start from that kind of very strong position. It is worth noting that in addition to Ermogenous, in most cases the family court now overrides these presumptions anyway. And so we can now have binding agreements in contemplation of marriage. We've got any family lawyers here, I can never remember what they're called, they've got some funny name. They're prenups in the state, that we've got some states, we've got some particular name here, I can't remember what it is actually. And as I mentioned before, we can go to Ermogenous. So, Balfour and Balfour, what is it? Rufus and Brewster is a good, sorry, let me just flip down and get all this. Rufus and Brewster is a really good case for, again, looking at what the objective facts are. So, got to remember which way round it is. I think the Rufuses were the parents-in-law of Mr. Brewster. We've got it around the right way. They didn't have the greatest of relationships. They'd had some disputes over time. Mr. Brewster had a truck, and the Rufuses also had a vehicle, a truck, a smaller truck it must have been. Mr. Brewster agreed essentially to carry the truck from Cooperpedy to Adelaide, is my memory, so it could get repaired. On the basis that he could get somebody to drive it back and it could be filled with a load that he would get paid for. So I assume they were both, it was a trucking family. Anyway, something went badly wrong on the way back, and the Rufuses sued Mr. Brewster for failing to get their truck back in good order and for the damages. And he said, well, hang on a minute, we had an agreement between us. That was the risk that you took. I was allowed to put things in it. It was a commercial relationship. It's for you to have the insurance in that particular instance. They said, no, we're family members. You're married to our daughter. This is a social and domestic relationship. It must have been the other way around, actually. Sorry. One party's claiming for social family relationship, the other one's saying, no, there's a contract and you have to pay. What did the court do? It looked at the whole of the relationship. It took into account the fact that the parties were not on good terms and that they wouldn't naturally reach out with love and affection for each other and help each other out, that each of them needed to have something in it. And they said, okay, objectively, a reasonable person would assume, based on the wider set of circumstances, that this was intended to be a commercial relationship. Another good one is Todd and Nicol. So this is Mrs. Nicol invited her deceased husband's sister and his niece as well, so his deceased husband's sister's child, to move from Scotland and come and look after her in her old age. And she was going to keep them she asked for them to come and keep her company, and on the basis that when she died, she would leave the house that she had presumably lived in with her husband to them. So they sold everything that they owned in Scotland. The niece gave up her job. They came to South Australia. They started living together. Now, it actually turned out that the Todds were not particularly nice to Mrs. Nicol. They behaved quite badly, and after a little while she kicked them out and said, I'm not going to put you in the will. And so the Todds sued her. they said, well, this was not a family relationship matter. There was a contract here. Argument for a contract was we were required to do these things. The intention, as we understood, was for this to be a legally binding relationship, and we acted on that intention. We sold up in Scotland. The niece gave up her job. We moved countries. We came here. So the court looked at that and said, yeah, objectively speaking, we can see that there was an intention for there to be a contract. As it turned out, based on the behaviour of the Todds, they said, notwithstanding that, we're going to stop you from exercising your rights under that contract because of other things that you've done, not so relevant here. But that's why it can be a confusing case, because at the end of the day, the Todds lost. But on the point of whether there was a contract or not, objective test, they found a contract. Sorry, let me have a look. Actually, I will go to the next one. Ashton and Pratt. Let's finish up with something a little bit more recent.
Wasn't there another one like that where it went to Sydney and they held there was a contract?
Because they travelled,
moved there,
probably.
And they won.
But they lost?
No, they won. And they got the will as well. In the will, we had to leave the house to them or something.
Ah, I can't remember the case though.
Is that Wake something in
Yeah.
Oh,
Ripley?
Ripley.
yeah,
Yeah.
something like that. Same principles.
Yeah.
Ashton and Pratt. So Mr. Pratt died a number of years ago now. He was a very wealthy man. He was not necessarily the most faithful to his wife, as it turned out. So he had a number of long-term affairs, and one of them was with this lady, Mrs. Ashton, who had essentially worked as a prostitute and provided services to Mr. Pratt over a period of time. And essentially, according to the judgment anyway, he said to her at some point in time, I would like you to stop being a working girl. I would like us to enter into an arrangement where you become my full-time mistress. I will provide you with housing. I will provide you with some money to support your children. I'm going to set up some trust funds for the kids so they get a good education. And you'll provide me with certain services in exchange for that. According to Mrs. Ashton, the agreement included, essentially, after he died, lots of people were coming out for the will for Mr. Pratt. Some of you will remember the press about it. He also had a number of illegitimate children who'd been staking their claims with various elements of success. I do feel for his poor wife who's fronting up to court fighting all of those things. But there was a lot of money to go around here as well. But his solicitor, the estate solicitors, argued and said that even if all of this is true, and much of it wasn't denied, this is a family, social or domestic context. This is not an arrangement where we would normally expect to see an intention for it to be entered into as a legitimate contractual relationship. So at first instance, Justice Brereton held that there were two key factors suggesting that the parties didn't intend to create a legal relationship. So what's the language he uses here? In the present case, the intent of the arrangements was to establish the basis of the relationship of, quote, mistress, end quote. The context was social. Although Mrs. Ashton agreed not to return to the escort industry, she'd already left it and was already embarked on establishing an alternative business. So it was not as if it was obvious that she was relying on an enforceable promise. The parties neither sought legal advice nor recorded their agreement in writing.
Ordinary people in their position would not have intended that in the event that either did not fulfil their respective promises, the other could enforce the promise in a court. There is considerable force in the defendant's submission that it would not have been envisaged that if Ms. Ashton returned to the escort industry, Mr. Pratt could obtain an injunction to restrain her, nor that if she didn't fully perform the role of mistress, he could claim damages for disappointment. What do we think? Gross? I want to call bullshit on it, personally. I think that this is laden with judgment. Okay, it is laden with, I guess that's what judges do, but this is laden with social justice, social judgment. And this is what we're paying judges not to do. Okay. Now, you know, I think Pratt was a slime ball. I think the whole thing is like distasteful and gross in so many different ways. But at the end of the day, I'm not convinced that this is an appropriate way to get out of the case. So on appeal, why is this not working for me today?
Did it freeze or?
So in 2015, this was appeal, and the appeal was dismissed. So we have 3 judges supporting this. On the issue of whether there was a binding contract or not, the fact that a contract constitutes a family arrangement does not raise any presumptions regarding the party's intention to enter into a contract. Rather, this forms part of the surrounding circumstances from which it will be determined whether the contract was formed. So Ermogenous was applied. I have no issue with that. The parties didn't intend to create legal relations, and even if they did, any contract was void for uncertainty. This bit I have less certainty around. I agree with the Ermogenous point, but if you take the time to read this case, and you know, okay, it's a little bit salacious, but at the end of the day, it seems to me, when you look at the facts, there are all these circumstances that keep arising that suggest that Pratt, at the very least, wanted to control choices that this woman made and represented it to be a legal relationship where her kids would benefit in the longer term. And I think to me, this feels more like it should have been settled in the way of, what was the bona fide settlement case we were looking at last? You know, maybe the parties had nothing either side, but because both parties genuinely believed promises were made to settle a bona fide dispute, the court said, well, yeah, okay, otherwise it would look like past consideration or fulfilment of an existing legal duty, but we're going to make an exception here because both parties genuinely believed there was a dispute and a promise was made to settle the dispute. It's not helping that I can't remember the court. And why do I like pulling this up? Partly because I think, gee, it's nice to have a case in this millennia, absolutely. But secondly, I think it's good for us to actually question whether or not cases are still being decided absent social judgment. And again, I'm happy when you've read the case in more detail, if you have a different view.
I wonder whether she might have been better going employment law.
I think she'd have a problem with employment law because, yeah, I think there'd be a number of issues
Or waiting. Was he still alive or dead? Was it against his...
It's against his estate.
Is this
So Judy Pratt has basically defended all of these other claims against the will. So...
Is that as far as the case got? Did it stop?
Yeah,
now?
2015 is where it stopped at that point. Yeah, I doubt that they've sought leave to appeal. You know, she has very deep pockets. So... intention in government contracts. We've come across this issue a couple of times now. as we've mentioned Australian Woollen mills a couple of times. So the question with entering into a contract with the government is twofold. One of them you will spend quite a lot of time in constitutional law, I have no doubt, dealing with, which is, does the government or the organ of the government that you're dealing with have capacity to enter into a contract? Can it sue and be sued in its own way, in its own name? But the other issue, and the one that I'm more interested in here, is the one of, is there an intention for a contract to be formed? And so the case where we talk about this the most, and it keeps coming up, is, I thought we have some cows there. Oh no, actually, sorry, I'm not going to Woollen Mills first. I'm going to go to Ley first. So, looks like it might not be an Australian case, but back in 1961, Papua New Guinea was an Australian territory. So, back at that time, they had a problem in the highlands of PNG where cattle were being infested by ticks. So the government had what they called a tick eradication program, and they went from farm to farm, spraying, I don't know what you do to a cattle to get rid of ticks, but they were supposed to be doing it anyway. It turned out they didn't know what they had to do either. They were mostly drunk and laid about. So Mr. Ley basically had these people come to his farm. They were supposed to eradicate the ticks. They actually caused a whole heap of bigger problems. So he sued the administration of Papua New Guinea on the basis that, for damages, saying, we had a contract, you were supposed to eradicate my ticks from my farm, and instead you caused all of this other damage. I need some compensation. In that particular case, damages were rejected. They said that this arrangement wasn't a contract, it was a service that the government provided. So we go from farm to farm, eradicating ticks for the benefit of Papua New Guinea as a whole, as opposed to entering into a contract with you to eradicate your ticks. We had no intention to be legally bound. This is a service that the government provides.
The consideration.
Well, the consideration is he let them onto his farm. I don't think there was any monetary payment as such. He did pay rates and taxes.
Is that not consideration?
Well, rates. So that's exactly, they're not, you have to pay taxes regardless of what services you take or otherwise.
So say for an example, you've got the rate to, within the council service that they provide you could be street sweeping, cleaning the streets, but they're not providing it. Your rates go towards the provision of that.
So think that through. So you pay rates to the council. The council, they're going to collect your rubbish bins, they're going to sweep your streets.
We'll do the rubbish bins out.
Okay? And then they don't turn up. Can you either sue the council for under contract for failure to collect your rubbish on the basis that, okay, 52, say we pay $520 in rate, I wish, 52 weeks of the year, my rubbish is supposed to be collected, but 2 weeks they're not collected, so I'm going to pay $500 in rates this time as well. Can I do that? The answer is no. Partly because it's not a contract. It's a service that they provide. The thing is, I'm an organic gardener. I've got a zero waste policy. My garbage bin is empty. Doesn't matter. I still have to pay my $500. It's part of the process. Again, governments get out of a lot of contracts on these bases. We're just providing a service. The thing is, I think the action was brought in the wrong place here. I think the action here should have probably been brought in tort. Because basically the government has sent employees onto his farm who've caused an issue. Yeah. And that we have a different connection here. So this is about getting the action brought in the right place. And that's with your council where you might have something, it's like, okay, I might be able to take action or a class action against the council because suddenly our streets aren't sanitary anymore and that's their job. Woollen Mills is another one where we use this same example. And we have this test in Woollen Mills that helps us see why we don't have intention. So it looked at Woollen Mills itself didn't have any statutory power that allowed it to make payments. The announcement that was made about the subsidy was made by a person who had no authority to bind the Crown. The Commonwealth had no commercial interest in purchasing the wool, and the Commonwealth reserved its right to vary the amount of the subsidy. So again, I just feel like in intention, all we have to do is go back to this question objective test. What would a reasonable person looking at all of the circumstances believe the parties to be doing here? And perhaps, and we certainly don't state this, but perhaps our presumption with government is government provides services and policies. We need to be very clear when we're dealing with government whether we're intending to be bound. So one of the things that you will do as a lawyer if you're working for a company that wants to contract with government is you want to be very clear that there is in fact a contract, that the intention is to be legally bound. And then we also think about this, often the question is one of sovereign risk, because when governments change, particularly when different political parties have different views about whether a contract should continue or not, then what does that mean for the way contracts are drafted? So some of you will remember when the most recent Victorian government changed, one of their election platform policies was that the particular road that was going to be built, they didn't want to build it anymore. So then there were costs associated with getting out of that contract because well-trained contract lawyers like yourself thought about that issue. I'm looking at you, Michelle. I know you want to get that train. I'm going to stop there actually because I don't want to start a whole new issue. I might do a 15-minute video to catch us up. Thank you for your time and energies tonight. If anybody has any questions, we'll keep going. But have a good break.